Welcome to the highly anticipated latest episode of Compliance Chronicles, where we bring you fresh insights on all things concerning real estate compliance. Join Queen Helen, the Compliance Queen, a seasoned and passionate real estate instructor across both North and South Carolina as she implements AI in education and real estate. Here she will share her love and expertise of licensed law with you, and empower you to confidently navigate through the dynamic world of real estate. Subscribe now.
Learning is a journey that never ends. In this video you will 1. Gain an understanding of the specific changes made to the contract forms in real estate transactions. 2. Comprehend the reasoning behind these changes and their importance in ensuring clarity and avoiding closing issues. 3. Understand the implications of the updated forms in terms of legal compliance and protection of all parties involved. 4. Develop the ability to navigate and accurately apply the updated forms in real estate transactions. 5. Learn how to effectively communicate with clients and other parties using the updated forms. 6. Acquire the skills necessary to ensure compliance with legal requirements when using the updated contract forms. Number 1. In a real estate contract, off-site, and separate lots refer to additional pieces of land that may be included in the sale. These checkboxes provide clarity to the buyer on what they'll be getting along with the main property, such as boat slips, parking spaces, storage units, or garages. Number 2. Deadlines for due diligence fee. The deadlines for the due diligence fee and earnest money deposit have been clarified to promote a smoother and more transparent real estate process. The new wording states that the fees are due on the effective date, encouraging agents to collect them before delivering the contract. This change reduces misunderstandings and disputes, ensuring a fair and efficient experience for all parties involved. Number 3. The revision clarifies that the attorney's fees mentioned on page 2 are not the sole remedy. If funds are dishonored, the seller can terminate the contract, reclaim the due diligence fee and earnest money deposit, and may also pursue attorney fees, court costs, and other remedies for dishonored funds. Number 4. Simplified. We're simplifying the process for handling the earnest money deposit to avoid confusion and disputes. The language in the form has been made clearer for everyone involved. Number 5. Form 2T serves the purpose of reinforcing a paragraph to enhance comprehension and reduce inquiries. The primary objective of this repetition is to mitigate any potential confusion and reduce the necessity to address multiple questions to NCREC related to it. Number 6. This passage addresses a common issue that arises when selling a house that contains exercise equipment. It's not uncommon for both the buyer and seller to dispute who has ownership of the equipment since it's considered a permanent fixture of the house. To prevent such conflicts, it's recommended to explicitly mention these items in the agreement between the buyer and seller. Number 7. To ensure fairness, the language has been updated to state that sellers who remove items from a sale must professionally repair any resulting damages. Additionally, buyers are allowed to provide additional instructions by using the Additional Provisions Addendum for repairs if they desire. Essentially, this rule requires sellers to restore any damage caused by their removal of items to a satisfactory condition. Number 8. As a potential homebuyer, it's crucial to conduct a thorough investigation beyond traditional home inspections. It's essential to be aware of significant factors that may affect the property before making a purchase. Researching any material facts related to government regulations such as laws, permits, adjacent land use, planning, proposed developments, road construction, or school zones during the due diligence process is highly recommended. This reminder is meant to help you make an informed decision and avoid any potential issues in the future related to the contract. Number 9. This message is a warning to ensure that a crucial piece of information is communicated to all parties involved, including buyer agents and listing agents. The warning primarily targets the seller and states that they are obligated to inform the buyer about any lead-based paint in the house. Failure to do so may result in the buyer being able to cancel the contract. It is important to note that the warning serves as a reminder of an existing rule and does not introduce a new one. The updated form says, "Failure to deliver before the effective date," means the buyer may not be obligated to purchase the property under this contract under federal law. Number 10. The new paragraph is there to tell everyone, including the closing attorney, if the property being sold has a lease agreement with someone renting it. It's like when you want to sell your old bike, you have to let people know if someone else is already borrowing or renting it. The new paragraph helps to give extra information about the lease agreement, in addition to what was already mentioned in another part of the document. Number 11. Language has been clarified to state that the seller only needs to convey the property free of any material encumbrances. The existing language has no such qualifier. This sometimes results in a buyer trying to use an immaterial encumbrance, such as a 6-inch fence encroachment on a small corner of the property, to back out of the contract after due diligence even though the seller can deliver marketable and insurable title. Number 12. This new paragraph obligates the seller to convey the property free of government regulation violations, except for those violations the seller discloses prior to the effective date. This paragraph creates a second condition of the contract, and therefore it operates similar to paragraph mark 11, condition of property at closing. Let's simplify this. In the event that a previously undisclosed violation is discovered during the transaction, it will not usually be considered a breach as this new section acts as a condition. However, if the seller discloses the violation, the buyer cannot terminate the transaction based on this paragraph. If the violation is discovered after the effective date, the seller has the option to either rectify the violation or decline. Depending on the seller's decision, the buyer can either continue with the purchase or get a refund of their earnest and due diligence money back. Number 13. It's common for agents to fill in the wrong name in the designated blanks of this section, leading to confusion during the transaction process. This confusion is exacerbated when the closing attorney and/or lender demand that the name on the deed be altered and the contract revised. With the new options provided in IV, closing attorneys can now effectively execute the contract's intent while also keeping the seller informed about who will be listed on the deed. This paragraph does not affect the contract's assignability, which is still prohibited in paragraph mark 15. 14. Occasionally, an aggrieved party in a transaction, usually the buyer, will record a copy of the contract in order to create a cloud on the seller's title. The added language here will make any such recording a breach of this contract, triggering the remedies in paragraph 23. Number 15. The binding clause. This offer shall become a binding contract on the effective date. This passage explains that on the effective date, the offer transforms into a binding contract that both the buyer and seller must adhere to. In the event that the buyer fails to provide the payment on time, the contract is not automatically cancelled. However, if the buyer does not deliver the payment, the seller may have the option to nullify the contract if it is specified in the agreement or if the law permits. This scenario is similar to when you agree to exchange toys with a friend. Even if your friend does not provide their toy immediately, the agreement remains valid. However, if they consistently fail to provide their toy, you may be entitled to end the agreement eventually. Number 16. These changes were approved to accommodate the change discussed in section 1.2.2 herein regarding dishonored funds. How do these changes affect your business? Do you favor the new contract updates? What would you like to see updated? Like, subscribe, share.